और इस वक्त आपको लाइव लिए चलेंगे। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत इस वक्त की जा रही है।
You added words to my words.
Yes, indeed. I'm taking the liberty of adding the words unless the Parliament says so.
I may or may not agree with you.
Of course.
Subject to your...
Grateful, sir. So, if I may move to the next point, this challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105, at page 107.
Please repeat the citation.
My Lord, PLD 1994, Supreme Court 105,
At?
107.
Okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61.
No, Supreme Court. The 2010 Supreme Court?
Page 61. This is, my Lord, Chief Justice Iftikhar Muhammad Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10, I have drawn out what these international treaties say. I will just read one sentence from there, my Lord. Independence of judiciary, according to the Council of Europe recommendations, says, the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather, which specifically says that from internally from the institution, there has to be independence. My Lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners. How independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the Parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the Parliament may make another law. My Lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so. But not at present. This law does not. My Lord, most humbly, under Article 184(3).
Ibrahim, how do you say that? Where the Act obligates the Chief Justice or the two other judges, rightly pointed out by one of the councils, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the Parliament will now dictate how benches are to be formed or how what cases are to be fixed by by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
सब्सक्राइब करें और बेल दबाएं ताकि कोई खबर रह न जाए।